This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a suit against an insurer will fail because the insured failed and refused to read the policy, or if he didn't care. And delivery of a policy to an insured starts the running of the statute of limitations. Wooten, the plaintiff, purchased 7 Northwestern Mutual insurance policies. 3 were disability income policies, 4 are various whole life policies. Wooten purchased and reviewed the last of the policies in December of 2005. He sued, claiming he was deceived about what he bought 10 years before the suit. In an action entitled Wrenn Wooten versus the Northwestern Mutual Life Insurance Company et al., the Court of Appeals of Texas, on July 31, 2023, worked to resolve Wooten's complaint that the trial court's grant of summary judgment in favor of the insurer and its employees was wrong. On April 17, 2018, Wooten sued, more than a decade after he purchased the policies. He alleged he was sold policies based on misrepresentations on coverage and benefits, was wrongfully advised by the agents who concealed and misrepresented material facts. Wooten bought the disability policies to provide income if he became disabled and unable to work in his present capacity of an MRI radiologist. Wooten alleged Jimzara misrepresented that the policy would provide disability income even if he were able to work in another field. Wooten also alleged the disability policies were unsuitable because they did not contain a waiver of premium term, contrary to Jimzara's misrepresentations and or omissions. He alleged a waiver of premium term would have allowed him to receive disability income without paying premium. Wooten has not filed a disability claim under the policies, and he is still alive, so there is no claim under the life policies. The suit alleged claims for fraud, negligent misrepresentation, breach of fiduciary duty, and violations of the Texas Insurance Code and Texas Deceptive Trade Practices Consumer Protection Act. Wooten alleged he did not discover the injury and or misconduct that forms the basis of this lawsuit until within 2 years of his filing the lawsuit. The trial court granted Northwestern Mutual's traditional motion for summary judgment. The trial court did not state a ground upon which it granted the motions. The Court of Appeal, therefore, started reviewing the law and started with the statute of limitations, which was the arguments made by Northwestern Mutual and the agents. Wooten alleged causes of action within 2 and 4 year periods of limitation. The statute of limitations for Wooten's claims for negligent misrepresentation for violation of the Texas Insurance Code is 2 years. The court concluded that the appellees, the insurer, carried their summary judgment burden of conclusively proving Wooten's claims for violation of the insurance code, the DPTPA, negligent misrepresentation, and fraud accrued at the time Wooten purchased each policy. Much to the surprise of Mr. Wooten and most insureds, an insured has a duty to read the policy, and failing to do so is charged with knowledge of the policy's terms and conditions. And so when the insured receives the written policy, it has sufficient facts in its possession to seek a legal remedy based on an alleged misrepresentation about policy terms by the insurer or its agents. The appellees conclusively demonstrated to the Court of Appeal that Wooten purchased his last Northwestern Mutual policy in December of 2005. The longest applicable statute of limitations for his claims on the policy and all his policies is 4 years. Wooten's claims for fraud, negligent misrepresentation, breach of fiduciary duty, and violations of the Texas Insurance Code and DTPA were barred by limitations unless Wooten was otherwise authorized to subsequently file his lawsuit and timely did so. He alleged that the discovery rule changed the accrual date. An injury is not inherently undiscoverable when it is the type of injury that could be discovered through the exercise of reasonable diligence. Wooten testified he reviewed each of the life insurance policies and disability insurance policies when they were delivered to him, 15 years before he filed his suit. Summary judgment evidence conclusively demonstrated that Wooten actually reviewed the policies and knew or should have known at the time he bought the policies and when he reviewed them that they did not provide the coverage or benefits the insurer and the agents allegedly misrepresented. Consequently, the insurer and its agents conclusively demonstrated in the trial court that the alleged injuries are not inherently undiscoverable and that the discovery rule therefore does not apply. Even in a breach of fiduciary duty case, where a fiduciary's misconduct is inherently undiscoverable, a breach of fiduciary duty claim accrues when the claimant knows or in the exercise of ordinary diligence should know of the wrongful act and resulting injury. The Court of Appeals concluded that by 2005 at the latest, Wooten knew or exercising reasonable diligence should have known of the facts giving rise to the cause of action. And therefore, because an insurance agent has no duty to explain policy terms to an insured has a duty to read the policy, and failing to do so is charged with knowledge of the policy terms and conditions. Therefore, the appellees carried their summary judgment burden to conclusively prove Wooten's last claim accrued in December of 2005, and to negate applicability of the common law discovery rule to his common law claims of fraud, negligent misrepresentation, and breach of fiduciary duty simply did not exist. In my opinion, an insured has a duty to read a policy to confirm that it received the coverage the salesperson represented. Although Wooten was neither dead nor disabled, he sought damages against the insurer and salespersons when 10 years late. He claimed to have found the policies did not cover the events he was promised. He sat on his rights well past the running of every applicable statute of limitations, and his suit was rightfully dismissed. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you found this video to be interesting or useful to you, please tell your friends and colleagues about the blog and the videos so that they can subscribe to the blog and the videos. It's free. And if you're interested in more detail about insurance, insurance law, and insurance fraud, and insurance claims, you can subscribe to my Substack publications or my locals community for a very small fee. Thank you for your attention.